hands. We pray this in Jesus' name. Amen.
Yeah, we'll start and we'll start and then ratify things next. And one member is on the way, but we won't keep our guests holding. Any uppers or absence? Okay, that's DPP and MOCA. And then welcome everyone, particular after the holidays. So I say Happy New Year to everybody. Thanks for last year, and now we proceed to see if we can get through this particular bill, which is an important part of this year's New Year pledge, is to get this bill amended and before the House quickly. We thank all the members for the work they've been doing. So we know today we're going to have submissions from the Manley Law School. All right, who are the representatives? Okay, thank you very much. And we're going to go straight into business. No, the minutes are deferred until the next meeting. All right. So we have our two colleagues. Once we have Member Golding and Chuck, we are in good hands. The legal luminaries, so we don't have a problem. Just work with them. And we have our technical team here. We thank for their efforts being here. So let's start with Madam Sek. Ready? Yes, sir. We can have from the Manley Law School.
Chairman,
can you introduce yourself for the records? Right. Introduce yourself so we have it on. Sorry.
Yes, I have a PowerPoint, but I'm not sure how to get it on here.
So introduce yourself for the benefit of our recording team.
Yes.
Yourself and the members of the team.
Well,
the names.
Yes, I was going to allow them to introduce themselves as they present. Is that all right? Oh, okay.
Well, introduce yourself.
Yes, my name is Nancy Anderson, and I'm the tutor with them today. We had done written submissions. Most of the students that have participated in the written submissions are here with us and wish to speak about their particular areas. I've asked them to be brief because you do have it in writing as well. And so I'm going to allow each of them. I was hoping that I would be able to turn this PowerPoint on. I don't. Yeah. I need some help, maybe. But yeah, you turn it on. Switch it where? Here? No. All right. No, I got it. Yes, as I said, we had sent in submissions at the late last year, and we're very grateful for being here. The first part of our submissions deal with a multidimensional approach. I'm going to ask the student to introduce herself.
Hello, good afternoon. My name is Kendra Dawkins, and I'm a second-year student at the Manley Law School. I will be presenting today on a multi-dimensional approach to the alleviation of gang violence or organized crime in Jamaica. What I looked at first was the statistics. The statistics shows that since the passage of the Act, there has actually been an increase in the number of gangs and gang-related violence in Jamaica. What this says about our Act is that there needs to be a two-tiered approach to gang violence or the formation of organization criminal gangs. The first approach is a suppression approach, which is what the government has done through the Act, but however we see that right now isn't the only approach that can be taken. The other approach, which I suggest, is a prevention or intervention approach through a multidimensional approach. In the government, in the national security the Ministry of National Security's study on violence in Jamaica. They had a 5-pillar strategy for crime prevention and citizen security in Jamaica. They suggested as 5 strategies towards alleviation of gangs and criminal organizations in Jamaica as community and infrastructural development, social intervention, law enforcement approaches, reform of justice system, and targeted communication plans. This 5-pillar approach, I'll say, can't entirely be an all-governmental approach. It has to be something that is done through an all-society approach. This would require the coming together of different stakeholders, non-governmental organizations, members of the community, and even church groups. For the community and infrastructural development, which goes in hand with social intervention, through this strategy, what could be done is that we could have increased mobilization by including local residents. We could have youth agencies, and there also is a requirement for the law enforcement approaches, in that there is a deep mistrust of people in the communities, especially garrison communities, for law enforcers. We have to do something about that to address the corruption of our law enforcers, which drives the mistrust of citizens for law enforcers, and thereby helps aids in increasing gang violence and the basic just mistrust for this entire system. The reform the reform of our justice system is also very important, as in 2015 it was stated that 170 persons were arrested, had been charged under the act, but by the year's end none of them had actually become convicted. And so far we've only had 2 convictions under the act, and those 2 persons have actually pleaded guilty. So a reform in our justice system, which is something that can be done with the working together of the Jamaica Constabulary Force, and also a reform to our actual court system through the court management system. A targeted communication plan would also require all stakeholders, governmental organizations, non-governmental organizations, people in the community working together. A plan where there is actually dissemination of information regarding the legislation, because a lot of the time when these acts are passed, persons have no knowledge of them. So these are my suggestions in terms of a multi-dimensional approach to the alleviation of gang violence and criminal organizations in Jamaica. Thank you.
Good afternoon. My name is Donovan Collins. I am a final year student at the Norman Manley Law School. I made submissions on the fact that there was no express provisions in the present act that gives police investigators powers to search without going through the normal procedure of getting a search warrant from a justice of the peace. Now, criminal gangs operating in Jamaica comprises of well-educated and organized individuals. It is my submission that if investigators are to be able to satisfactorily investigate these gangs, they should be given the power to search premises without actually going through the difficulty of getting warrants from a justice of the peace. What happens
It has a very good point.
Yes. What happens is that when officers are on these operations, which are most times intelligence driven, they might be searching one premises, and whilst there, they are given additional information on other gang members or major players in these gangs. Now, if it is that the officers have to leave the operation to get warrants to search additional premises, evidence can be displaced by the officers who are back with the warrants. So what we're suggesting is that, similarly to the Dangerous Drugs Act of Jamaica, which gives the police authorization to search, we are suggesting that the same be done to this act. I know that there are concerns about giving too much powers to the members of the JCF. So conditions different from those provided under Section 21(4) of the Dangerous Drugs Act could be put in place. For example, under Section 21(4), the Act provides that any member of the JCF above or far above the rank of sergeant may give a constable authority in writing to search. What we are suggesting is that in this act, we improve that to a gazetted member of the JCF. Those are my submissions.
Thank you very much, sir.
Good afternoon. My name is Julianne Hewitt. I'm a second-year law student at the Norman Manley Law School. I will be speaking to two issues in particular: the definitions included in the interpretation section of the Act, and also as it relates to the proposal made in relation to pre-detention. The Act, as we know, the interpretation section is quite vital because it aids with the applicability and of the Act itself. We've seen in the Act where some of the definitions that have been included in themselves are vague, or it's not quite succinct enough to give clarity to how the Act itself should be applied. I refer particularly to benefit. The definition given for benefit is that of service or advantage. The scope is not limited, and that's something that we're proposing, because then it leaves, concern to say, is it that any benefit or any advantage that's given to a member who is involved in criminal activity would amount? So for example, let's say somebody gives a ride. Will that be considered an advantage that's under the definition of the Act? So if someone is given a ride or helps a neighbor, is he providing a benefit to a criminal organization? So what's the scope? It's vaguely defined in the Act. I also refer, sorry?
Giving a ride with knowledge that you're giving a ride to a gang member for the purpose of the gang is an advantage, is a benefit, I think. And the definition is money or other property, service or advantage. Yeah. So it's deliberately wide, but it requires mens rea. Yeah.
That's right. How it's phrased is includes any money or other property, service or advantage. So I'll pose a question then. If somebody provides a meal as per se an advantage, would that be constituted, would that amount per se to somebody providing a benefit to a criminal organization?
If they have knowledge that they're providing a benefit to a criminal organization, yes. Where would you draw the line? 1 meal, 3, 10? a feast? Or would you say food is not a benefit? We shouldn't exclude
It's not so
food?
much in the meal itself. It's just how it's phrased. It's vaguely phrased as to what exactly can be considered under the scope of what is a benefit, or particularly what is an advantage.
How would you propose limiting it? What would you want to exclude?
Well, what we could probably do, what is it that we propose is that we somewhat contextualize what service or advantage could mean as it relates to the interpretation of the act itself.
If you can, try and be a bit more specific, because I didn't really get anything out of that.
True.
Right, as you'll appreciate, if the person has no knowledge, unlikely. A little knowledge, a whole heap of knowledge, definitely. So knowledge is important.
And I do agree, which is why I'm thinking that could be incorporated in the definition itself.
No, it shouldn't
But you
be in the
never know.
definition.
You never know how much knowledge until it comes out in evidence.
It's in the offense, the nature of the offense. Mens rea is required. So knowingly providing a benefit to a gang is an offense. Now, what is the nature of the benefit that you would want to exclude? Transportation? I wouldn't agree with that personally. Sustenance? I wouldn't agree with that either.
No, you
So
couldn't
I
agree with that.
think if you want to circumscribe the definition, you really have to come with something specific. Yeah.
I can see your point, but I said you have to be careful because, for example, a ride sounds simple, but if you're going to a working class community, the taxi driver is often the person who transports the gangster all over the place. He may not be a gangster, but he has no choice. You'll have to bring this up in evidence so you can prove that he's really being done so by coercion from gangsters. But you can also have the driver who is the main architect of the operation and moves them all over. So it has to be brought up and then decided by the evidence and the court system. So you have to be a bit careful how you...
And always the
as
challenge...
an innocent right is it, because I know it's a big challenge now, a lot of the communities.
The challenge is to prove just how much knowledge.
That's right.
Yeah. But it's vague because you can't be specific.
Okay. I'd also like to refer...
That's what gives the lawyers work, you see. The prosecutor versus the defense lawyer.
Okay. Thank you. I also like to refer you to the definition that's given for law enforcement officer. In 2014, I believe, I'll read the definition that's provided here, particularly for subsections A and B, I believe. That's right, a member of the Jamaica Constabulary Force, and B, a member of the Island Special Constabulary Force. I do believe that in May of 2014, there was they had successfully merged both the Island Special Constabulary Force into the Jamaica Constabulary Force. So I do propose that the definition be reworded accordingly, seen as though they were both merged. That's the Jamaican Constabulary Force. It was, island...
When that was done, typically, because there are references to the Island Special Constabulary Force Act in lots of different pieces of legislation, typically when something is done like merging them, and that is giving statutory force, the statute that does that would provide for how references to that act in other pieces of legislation would be interpreted. So, for example, when we changed resident magistrates courts to parish courts, there's a provision in the amendment to the Judicature Resident Magistrate Act that provided for how references to the RM court in other pieces of legislation should be construed. I suspect that may have been done, but if it hasn't, then I agree we could modernize this.
That's right. Those are my submissions as it relates to the interpretation section. Thank you.
On your Mr.
Donovan Collins, sir.
Yes, Mr. Collins. You cited the Dangerous Drugs Act, and So your main issue is that rather than requiring a JP to sign the warrant, the authorization should come from a gazetted officer. That would be the proposal you're suggesting for search warrants.
My proposal is that a gazetted rank officer should have the power to authorize police officers to conduct searches instead of the officers needing to go to a justice of the peace for a search warrant.
You want real-time search?
No, but to be fair, first of all, GPs are readily available, or should be, okay? But more importantly, if you give such power to the police force, don't you see the possibility, real possibility of abuse?
Remember, you're looking at in pursuit of gang members. So it would not be an all-embracing power to the police to change their authority. But the point is, if you go to a community where there's a number, you have confirmed reports that the gang is based, which is well known and published how many gangs you have. They go to the community with one search warrant. But when you're there, indication or hints that you should maybe search the neighboring house who is not necessarily a gang member, but he is in the community where they have to allow him to hide stuff there. They should be allowed to go there. I think that's the idea that's coming there, which makes sense. It like every law enforcement act dealing with a specific group, the likelihood is there, the potential is there for abuse. I think it's a question of how it's administered and the level of integrity of the force. But this is something that would make some sense. But I see the possibility that
I can see the point you're making.
Bear in mind, the JP himself, if he's there,
no, but let us say,
he can sign a document like that, in the presence of
in many areas, you have what is known as big yard. Big yard and big yard usually have 10, various chattel homes. And let us assume you got the warrant to go and search house in big yard. And let us assume they search one house, and the feeling is that they search a wrong house, or they should search 5 houses. The impression I think should be put is whether or not the warrant should not be taken out to search houses in big yard, right? Because to be specific that you only want a warrant to search house number 3 away from the main road is very difficult. So you're going to search property in big yard, because in most of these inner city communities, these big yards have several homes. It's a different matter though. If you're saying that even in the inner city community you have 2 houses separated by fence, and you get a warrant to search one which has a known address, and having searched it, you feel that you should search the next house, and you just go over there without a warrant. I mean, I think that would be stretching it a bit far.
That's a matter being raised, and we need advice. But I think that's the reality. The practicality of it is attractive, and all gangsters at all based in big yard. That may be so in Grandspan, but that's not true. Many gangsters occupy some very, very opulent places, and the last man in Montego was killed in Iron Shore, at the top of in Terrada Heights. Okay. No, but if you had gone there, and there are several houses up there that they find they have taken over as well, in Terrada Heights. Now, if on a specific mission for one house, the officers got there and figured that's another house that they have an interest in, and then they may go. Because look, nobody's going to hide their criminal equipment on the particular place they're living on, except for partial, to protect themselves. They're going to hide it next door where nobody's going to go. If they get information, then it suits you to have that capacity in pursuit of a gang. I think the question, the challenge is how do you make sure that it is. It's a challenge. You're the legal minds, I be advised, but I think from a practical point of view, I can see the value of having that ability, specifically related in pursuit of gangsters and in the area.
Chairman, I've come in at the end of this. I find a very interesting
Well, you should,
discussion.
Mr. Rennie, you have some young minds, sir, from the law school here. Mr. Anderson brought them. I know as an elder you respect that. These are young, finally law students by and large, who are giving their comments on the matter before us.
Yes.
And we are to take, looking at some of the fresh light they have brought to the matter.
Would this novel idea be applicable to a townhouse complex in Upper St. Andrew?
Answer?
And bear in mind, it is suggesting that it should be a gazetted officer who have the authority to do so. So it's not just every police officer run up, knock on the door and decide I'm going to search every door down the road. There must be somebody at a certain level who can exercise some discretion and say, look, I just got information and I think that these two townhouses or that house, neighbor's house, ought to be searched because of ABC. But there must be some basis for it and somebody with a level that is allowed a level of discretion,
As
not just
I
any officer.
understood Minister Chuck, there was some extension to this thing, and he's saying in big yard, whether or not the warrant should be just to search big yard. And so I just wondered if the warrant would be to search big townhouse complex. You know, I just want to know, whoever signs it.
The answer to that, sir, is yes.
I think, before, yes, gentlemen, what Minister Chuck said, I think, is more risky, I know my young colleague will say, than what you're suggesting. Okay? If you're going to get a warrant for an apartment complex, it might be 500 apartments. You're going to, because there are two criminals. It doesn't, that's not logical. It's easier to say when the superintendent in charge is there, he has new information, or by virtue of his observation, he figures it's appropriate to search an additional 2 houses. And the officer in charge takes that decision. You take on a warrant to search everybody house in the apartment block of 40. No, man. That don't strike me as being, I think the young man's suggestion of a gazetted officer, at least at the level of a deputy superintendent, is present and may indicate to his officers that they need to search. I think from a practical point of view, but from a human rights point of view, I feel more comfortable with that suggestion. I don't know what the law think.
The only thing I'd say, the precedent that Mr. Dawkins was relying on is in our law already, in the Dangerous Drugs Act, and he cited the section, and that section enables an officer of the rank of sergeant or above. So the question really arises, given you want to have some kind of operational flexibility where a person who is on the spot, so to speak, intelligence develops in the course of an operation, you really would like to search that yard because you have some reason to think that there may be guns in it or whatever. You know, why would you want to frame the rule in a way that's more restrictive than in the Dangerous Drugs Act? I'm just asking that question because I'm not hearing any proposal to amend the Dangerous Drugs Act to raise the bar higher. So
no, well, I'm comfortable with that legally. I just thought it was more responding to Minister Chuck's point of view that if the officer in charge, what I expect would be at least a sergeant, I like the other inspector and upwards, should be there because
if there is something problematic about having it framed in the way it's already framed in the Dangerous Drugs Act, then we could consider not going down that road. But I haven't heard anything really specific as to why we wouldn't just adopt that approach.
I take your suggestion, man. I'm sure the young men would look at your suggestion, just accept what is in the Dangerous Drugs Act. It's already there, and there's no challenge to it constitutionally. So it would be a good clause to insert in this.
Well, I was of the view that there would be a lot of persons in Jamaica who would believe that the police have too much powers. So in order to restrict the amount of power in the lower ranks of the JCF, I suggested gazetted rank who would be more responsible than a sergeant of police.
I understand. I'm just thinking if the justification for not requiring a JP is to facilitate operational flexibility, I'm not sure that raising the bar achieves that objective, given that there may not be a gazetted officer on the particular operation, if that's the issue. I understand your point, though. Yeah.
Based on research that I've conducted, I found out that most operations in Jamaica that officers go in search of gang members, they are most times led by gazetted members of the JCF. So where operational efficiency is concerned, a gazetted officer would normally be on the ground, and if they're not on the ground, they would be nearby.
Thank you. Well, that's very useful.
You're welcome, sir.
Jake.
In preparing our submissions, we also looked at what were some of the proposals by other external entities as it relates to the Act. We do know that there were some proposals by the Jamaica Constabulary Force that suggested that the Act should allow for a possible extension of 7 to 14 days for persons to be held. And we are proposing that not to be accommodated based on the fundamental right to liberty, as we know, which is guaranteed in our fundamental rights and freedom. Also, if we do go ahead and extend, it would somewhat be oppressive to the persons who are detained. We are aware of the detention, lockups, and the sanitary situation, and just the confines of being detained. So having to wait 7 to 14 days before being charged would be an unreasonable period, and as such, we propose that that submission made by the Jamaica Constabulary Force not to be taken into account, to be amended, for any amendments to be made to this Act accordingly.
Good afternoon and a happy new year to all. My name is Danielle Bullen and I am a first-year law student at the Norman Manley Law School. I will be focusing on some procedural aspects of the legislation. So specifically, I would like to turn your attention to Section 18 of the Act, and there it states that offenses charged under the Act are to be tried by a judge alone and in the absence of a jury. So while there is no express right to have a trial by jury, the Charter of Fundamental Rights and Freedoms at Section 16, it does guarantee a right to due process. So the question we must bear in mind is that in the absence of a jury, will this have implications on this right? So with this in mind, what are some recommendations? So we propose first to look at some international examples, and then secondly, to some alternatives to the jury system entirely. So looking internationally, we took note of a recommendation made by the Human Rights Committee of the International Covenant on Civil and Political Rights. They were examining the Irish Special Criminal Court, and there they suggested that non-jury trial should be specifically requested beforehand by the DPP. And then in the UK, that actually occurs. However, there is a requirement for the prosecution to show that there's evidence of a real and present danger of jury tampering. So if the intention of this procedural mechanism in this act here in Jamaica is to avoid jury tampering, perhaps a similar approach would be useful to employ in Jamaica. Now I move to an alternative to the jury system entirely. So one suggestion was made by Professor Rosemarie Belantoine. She's a dean of the Faculty of Law at St. Augustine. She suggested instead of having a jury system, perhaps maybe a panel of 3 or more judges could be used. And if that would strain resources, perhaps maybe a panel of a judge and some attorneys acting in the capacity of the jury. So in using these methods, it addresses some issues of impartiality, potential jury tampering, and concerns of intimidation. So to conclude on my point, although there is no right to a trial by jury, it is still useful. It's still the trend internationally. However, the recommendations from the Human Rights Committee may be useful for Jamaica's case, or the panel of 3 judges or more might also be useful given the circumstances. Thank you for your consideration.
Okay, good afternoon, everybody. My name is Miss Connor LeBlanc. I am I'm a final year student at the Norman Manley Law School. I am presenting on the training of JCF officers. I must admit before going any further that my research was based on the Police Academy's website as well as speaking to officers, current officers. Basically, I tried to look at whether the training of officers now in regard to the Criminal Justice Suppression of Criminal Organizations Act is sufficient. And I realized that there are different levels of investigation training that is offered by the Academy. But of particular importance was the major investigation level 1 and major investigation level 2. Now, from my understanding, these are course offerings by the Academy rather than in-service trainings. So major investigation level 1, I'll read for you. This is a course offered to police personnel assigned to the criminal investigation branch who have never been formally trained in criminal investigation. This is a 2-week course, and it is aimed at enhancing the skill of officers when interviewing witnesses and victims. I went on to read a little further to understand that if an officer was unsuccessful in the criminal investigation level 1, major investigation level 1, he would not advance onto major investigation level 2. And just for context, major investigation level 2, this is a 4-week course offered only to individuals who have been successful in completing a level 1 major investigation. Level 2 has a qualifying exam, and even if you pass the qualifying exam, you have to be interviewed for selection. This was particularly troubling for me, because this basically meant that if a police officer was not successful in his selection or in the entrance exam or whatever the case may have been, he would be limited to knowledge of only interviewing witnesses and victims. I did put together some, and before going any further, I also looked at the Academy's website is very limited. It doesn't speak too much. It just gives a brief synopsis of the course offerings. One of the things that I noticed that was not there is that there was no mention to legal training or sensitization of the law. Again, that was very troubling for me because we are asking officers to enforce a law that the layman obviously would not understand. They would need to break this down in such a way that they are, basically they understand it, they can enforce it, they understand it, so they can enforce it to the best of their knowledge. So I did do some suggestions. I said that a committee could be put together to develop or to look at the course offerings of the National Police Academy, National Police College of Jamaica rather. Consideration could be given to joining both major level investigation 1 and 2, therefore allowing all officers to be exposed to more than 2 weeks of training, and therefore not limiting them to just skills of investigation. Interviewing skills. I also thought that it was necessary that course or basically a sensitization course be developed to offer to and be offered to JCF police in training, so that they can have a better understanding of not just this law, but all other laws that they are expected to enforce. I think it is very important that if we are asking them to enforce a law, that they understand the law that they are about to enforce, or they should be enforcing. I also said that we could commission a study into characteristics of 21st century strategic policing using technical aids and geographical mapping. And final, this may be a stretch, but it's hopefully something that you guys can look at, that we require police officers to take what I consider to be a refresher course in investigation, thereby keeping them up to date as to adequate and useful policing measures, or investigation measures. These are my submissions. Thank you.
Chairman?
Go ahead.
Okay, thank you for your submission. That information was garnered from a website? Okay, and you mentioned that what obtained from the website could very well be a synopsis of what is offered, right, of what exists. Is it possible that the police could very well defend themselves by saying that what may be there on the website, it captures just an essence of the business of what they really are about, because you went on, the suggestions that you gave are very useful, but to the extent to which we can say that this is not already in practice with the police, I am not sure.
Okay, I also mentioned that I had spoken to other police officers who would have gone to the police academy. In fact, I hope Donovan doesn't mind, but he's a police officer by profession. He has, okay, well, not anymore, but he was. And from that, I basically concluded that this is not the situation there. He did say that they have a legal department, however, it is not a legal department that offers, it is not a course offering kind of legal department. And that's basically it. So I would have formed my conclusion or made my suggestions in that light.
Thank you for the effort in doing the research, and there's some ideas there. I think, in fact, the police force is putting in place, the commissioner is looking at putting in place an anti-gang sub-team of the CETA of the police force. I would assume that we get that in place and do the training you suggest when you put them there.
I'm sorry, I didn't hear.
I said the police force is looking at putting a special sub-squad for anti-gang operation. And maybe worthwhile looking at some of the suggestions that all members of the anti-gang operation will be trained along the lines you have suggested. I'll convey that information to our commissioner. Thank you for the work. But not hearing?
No,
the audio is not very good. I was just saying that the commissioner is looking at putting in place an anti-gang squad within the force, with the CTOC, the section for terrorism, counter-terrorism. And it would be useful to look at these ideas you have suggested so that all the members of that squad would have the complete training here alluded to. And I think their police officers here would see it. And then...
Chairman?
Senator?
Thank you. This suggestion that Ms. Connolly made seems a little bit wider in that it really presents a difficulty to a police officer on the beat, let us say, who is faced with the responsibility of enforcing the law.
Senator, can you come a little bit more closer to the mic? I'm not hearing you.
Yes, enforcing the law. And what happens is that we in Parliament, we pass some complex laws that give some difficulties to seasoned defense and prosecuting lawyers. But the police officer, really, I don't know of a system in place where when these laws are passed, that the force in general, or at least those who are enforcers of the law, because some are in the office, are assisted. And I think that's where you were going, that you felt that there was a lack of training for personnel who were expected to know the law and to know how, for example, to formulate charges arising out of the particular statute, etc. And so this is something that perhaps they could look at. How do they broaden training opportunities? And you had mentioned the police academy, Twickenham Park, but it need not be. It need not be. It could be, well, I wasn't even thinking so much online. I was thinking it can be done at what is known as the area level or the divisional level, you know. So the academy would be for other purposes. But the point you make, I think, is one well made and one worth pursuing.
Chair, on that same issue, if I may, just to say that I fully endorsed as well, and I think that it's a major gap in how we approach law enforcement. This piece of legislation was something that the police had been clamoring for many years, and they got it. But the truth is that it created a whole new approach and regime, and it has taken a couple of years to work out how to go about prosecuting these cases, and they have developed a protocol where they work closely with the DPP's office all through the stages now, and we are seeing a much larger pipeline of prosecutions that are about to come into trial. So there's been although we haven't had many trials, we've had a couple of, I think, guilty pleas. You made that point already, but there are a significant number of matters that are about to come to trial under this legislation. But apart from this, there's the DNA legislation, which I think there needs to be some serious training around, because how you deal with suspects under that legislation, invasive and non-invasive sampling and the protocols around that, those are things that the police need to fully be aware of and understand. The lottery scam legislation, all these major pieces of legislation that are driven out of the Ministry of National Security as a result of what MOCA and the JCF and the JDF see as necessary. There's also legislation as well, and how it applies. These are things where I think there ought to be an ongoing training requirement, just like there is for lawyers, and I think for doctors, for the police, because the law is constantly evolving and they need to understand it and be familiar with it.
I take your comment, Member, I'm sure it relates to what the young contributor has made Part of it is the squads that are directly involved could be taken to the college and given more intensive program, and but every law enforcement officer be properly oriented in the area level, so an ongoing continuing education. CMP, continuing police, CPM, police education.
So, Mr. Chairman, if I may, it's very interesting because I've had occasion to see the name Connolly Black before. I'm not quite sure. If I may, Mr. Chairman, before I go into the substance of it, were you a guild president or you ran as a guild president or something? No, but I know her name before. I've seen the name.
You're not allowed to canvass near sort of.
No, it's not canvassing at all. No, it's just that I just think it's interesting that when there's name recognition and then you see a young lady who obviously did something on campus, why her name is recognized, and then you see her here in this setting with none other than my dear friend Nancy Anderson. So it sends a good signal about the youth of Jamaica taking an important stand, and this is not just talk, it's her taking action. So I want to commend her for having done the research and for being here in Parliament presenting. Thank you. Just to say, Mr. Chairman, that whilst I was practicing at the defense bar, I always wondered why in terms of her suggestions, perhaps we could have, I know the DPP is always in need of resources and more personnel, but perhaps there could also be, I know they have different units, perhaps there could be a unit that deals with in terms of aiding the police to actually go from, whether it's at the divisional level or the station level, to engage the police and actually help them to better understand some of these laws. So that could also be a link between the police and the DPP in terms of working out those semantics, because the truth of the matter is that sometimes cases do come before the court and they fail simply because of the police lack of understanding of the law or the nuances surrounding that particular law to ground a conviction. By the time the statements are written and everything gets to the DPP, there really isn't anything for the government, well, for the Crown to go on, and they fail. If there is a closer working relation between the police and the DPP, that might serve to assist that. Senator Golding mentioned some of the legislation. I wanted to add the cyber crimes to that as well, because again, the cyber crimes, it's an intricate piece of legislation, and I don't think there are many police officers who have the training or that understanding to say, well, this is what we're looking for and this is what we need to ground, to get the statements together, to ground the prosecution, to ground the charge, to take it before the DPP. Even something as simple as Justice Batt's decision that was made a few years ago, there are still a lot of police officers who stop persons on the road, and just to say, well, there's a car matching this description, or we believe, just something to even ground the suspicion at the very get-go, as opposed to just, yeah, me I stop you, I want to search a car for that. But there's no reason given, in keeping with the nuances of Justice Batt's decision, just those simple things. So I think that sort of ongoing training, creating a better link with the DPP or some other office would be useful as well. As it relates to the Council of Human Rights, or the Human Rights Commission, Mr. Chairman, I thought those suggestions were very, very interesting. I was saying to Senator Golding that I've never thought of the idea of a judge working with a panel of maybe 3 or 4 attorneys to kind of get that, But it is interesting. There are some persons who might express that there might be there might be some persons who express a sort of conflict of interest. But even if we were to look at retired judges, because retired judges, I mean, we tend to rely on them for varying commissions. So if we are, I don't think I'm in favor of doing away with jury trials. I've seen how jury trials assist. Certainly there might be cases where we could say, all right, this could go by a judge alone. But if we had even a panel of 1 judge and maybe 3 or 4 retired judges just to assist in that process, because again, I find that much to do in terms of finding someone guilty or innocent has to do with your understanding of society, of people, of human relations, of what prevails in society, and that might help with just having the understanding of one person. I'll never forget, Mr. Chairman, why I did a case, and it wasn't even a criminal case. It was a family matter. It was a divorce, and the judge refused. This is when when you had to go before the judge for the judge to grant the order for the decree nisi. And I'll never forget, the judge said to me, Mr. Terrelong, are you suggesting that that the circumstances are fit and proper for the family? And I said, yes. This was a mother with her 2 children filing for divorce from an abusive father. And as far as the judge was concerned, the fact that the brother and the sister were going to be in one bedroom, there was shock and horror for the judge. And I said, but Judge, I was raised in a room with my sisters and my brother because that was the circumstance that prevailed. It did not mean that it did not mean that I had bad parents or that something was wrong with the household. But there are families in Jamaica where there's nothing wrong with 2 children sharing a room or 3 children sharing a room. But in that judge's mind, he did not see that why he should grant a divorce, because a boy must have his own room and a girl must have her own room. And he went on to speak about molestation and incest and all these things. And I thought, Judge, where are you coming from? So his reality would have prevented the grant of a decree nisi, as opposed to what prevails ordinarily. So sometimes I believe it's best to have multiple heads considering these things as opposed to just the view or the opinion of one person and their reality, which might be limited.
But I think the young ladies may be more acutely aware of the gang circumstances. Only recently I know there was a senior counsel sitting at a panel, and after one gang member came in, he said the look on his face made me begin to seek protection from the police. No, it's a very senior member of the bar, and I think the proposal not to abandon jury from what our suggestion is, that if in case of gang trials, it may be worth the while. It's a real issue. And while I know it has to do with the question of fairness and our whole question of jury trial and is being examined, I think it's good to see the young members bring it here, because it's not a matter of overbearing and denying justice, but there are real problems in dealing with gangs. Plus, there are multiple members in a gang. So jurors themselves are living in the same community as gang members. It's a trial by a jury, trial by your peers. It raises issues, whether or not in this case there's not room for it. So let's look at it. But I'm not.
Could I just add to that? What she didn't have a chance to say in a longer presentation was that the system that's done in England and the system that was suggested in the Human Rights Council was that that the prosecution had to come with some reason for a trial by judge alone, and the defense had to be heard. And there will be times in which both the prosecution and the defense would prefer a judge alone, maybe, right? But fairness requires both sides to be heard.
The amendment to the amendment that we dealt with in the we allow, except for capital murder, if the death penalty is possible, if they're being clear, then it doesn't apply. But in any other offense, the prosecution and the defense can agree to have a judge alone trial. That's in the law now. We pass that now.
The member from. No, the gentleman you're trying to get on first.
I just wanted to say thank you for your feedback and your comments.
Opposite the back.
Yes. Good afternoon. For the record, my name is Jeremy Taylor. I'm from the Office of the Director of Public Prosecutions. In relation to the issue of the training of the constabulary force, we welcome the comments. However, I should say it has been my experience that the JCF has been very proactive with its training. And let me give an example in relation to the Act, which is under discussion at the moment. When this Act was passed in 2014, myself and other members of our office saw ourselves going from St. Mary to Hanover, all over the island, dealing with training for police officers in this matter, not only for the counterterrorism division, but also for general CIB officers in the rural parishes, and also what are called the proactive investigative units, the PIUs, that deal also in rural parishes with the lotto scamming offenses and the gang offenses outside of Kingston. So a lot of training has gone on in relation to it. In fact, so much so that the last time I think they asked for more gang training, we had to decline, saying we were all ganged out. If there wasn't any other offense that they would like to go and concentrate on. But they have. It has also been the same in relation to the DNA the DNA Act. The police have been proactive, and between our office and them, and also, some sponsorship from some some NGO community, we have been doing the training. In fact, up to December, cybercrimes training was done with members from our cybercrimes unit. So in all the areas that you've identified, gang, DNA, and cybercrimes, a whole lot of training has gone on. In fact, these are the sexy areas of investigation right now, in which a whole lot of training has been going on between the Office of the DPP and the Jamaica Constabulary Force. And trafficking in persons, I am also reminded. So there's been a lot of training. I will give them credit for that. They have been very proactive. In fact, let me give another example of how they have been proactive. When the Committal Proceedings Act was a bill, the JCF, in collaboration with our office, again all over the island, prepared themselves for it. So that when the act came in force, there was only one institution that had a standardized procedure from Morant Bay to Bloody Bay, and that was the JCF. It is when the judges got hold of it that you got the cultural changes now, that it is done differently in Westmoreland than it is done in St. Thomas, than it is done in St. Mary, than it is done in Clarendon. But up to that point, the JCF had a standardized approach to committal proceedings. So I don't want you to go there that while you can't have too much training, that they have not had any at all in relation to this. If I may just make a point on the jury, there is already legislation that allows for the consent of the defendant to be tried by a judge alone.
Yeah.
So you can even, and we've in fact,
if I could just interject at that very point, it's actually an amendment that was made to the Criminal Justice Administration Act by the Jury Amendment Act of 2015, and it's a new section 11A, but it requires there to be agreement in writing between the prosecution and the accused, or each of them if there's more than one accused, for the offense to be tried by a judge alone. So it's by agreement of both sides, but it does not apply to an offense referred to in section 31(1) of the Jury Act, which is the capital
yes,
murder.
so, and in fact, we've actually done matters like that already, murder matters in which there has been agreement to be tried by a judge. It is not done often. I don't know if Mr. Terry Long can speak to his colleagues at the private bar, but it has been done. It is not unknown. In this case here, however, I would just say for practical purposes, we would not wish for these matters to be tried by a jury. Already in some parishes, and the parish that the chairman of this committee is perhaps very familiar with, you can't get jurors to come out and try murder cases. In fact, St. James has been appalling in relation to the amount of jurors that come out. In fact, I think the circuit opened with 20-odd on Monday, 20-odd jurors that have come out to do jury duty. And they will tell you informally, at least in that parish, the difficulty that they have in sitting and trying cases like that. Usually there is some kind of organized crime or criminal organization element to it. So I think, with all the reservations in the world about human rights and so on, bench trials are the best way to go for these kinds of offenses.
Thank you for that contribution, Mr. Taylor. And I must say I'm very pleased to hear what the police, I know we have some work they're doing, but the extensive level of training that goes on in terms of sensitive law, and that's why I'm aware that in recent times you have had, as indicated one member, there's quite a few cases in the pipeline now on the Anti-Gang Act, which suggests that there's a greater awareness and knowledge of how the law should be applied. But it's good to hear what you have had to. Certainly on the last matter, I'm in full agreement with you, as we are saying to you. You're lucky you got 20.
If I may, also in relation to education about the law, apart from the fact that I think my colleagues here and I take phone calls every day from police officers at all levels within the system seeking advice. We actually do go out to the National Police College. We do courses with them, whether it's what I don't want to have, you know, if it's high potential, you know, or also on major investigative court, but we do it, even going as far as to do mock trials with them, how to give evidence in court. So again, it is already incorporated within the course of study at the National Police College, and the officers from the Office of the DPP go there on a regular basis.
Sorry, if I may, and just to follow up on what Mr. Taylor is saying, I'm Alethea White, Director of Legal at JCF. So separate and apart from the training at the Police Academy, there are countless workshops and seminars that the JCF puts on in collaboration with our partners from the DPP, National Integrity Action. There was even recently, last year in September, a weekend workshop put on by NIA for the JCF, particularly focusing on this piece of legislation, where persons from the DPP, FID, even persons from the US, their FIB, and Belize came and presented for, and it went on throughout different weekends. So it is not just what you see in the police academy. There are internally many arms dealing with training. There's even a training department at the JCF that takes it on. So while we appreciate that there really can be not enough training and awareness, the JCF does prioritize that in its organization.
Thank you.
Chairman, just so that my colleagues outside will understand my position. I have not entered into the discussion concerning trial by jury. I have not. But to them, I say my position remains the same. They will understand.
Mr. Anderson, any further?
Get used to this. No, I want to thank you very much for allowing the students to come and to speak and to listen to the comments and try and answer some questions and to hear your concerns and for you to hear their concerns. Thank you very much.
I'd like to thank you on behalf of the members of the committee and the House for bringing the young team here. Young law students, it's good to hear some new ideas, and I want to commend them on the research they did in trying to make suggestions on this piece of act. It's good to have this kind of input in what we're doing. In fact, we hope you'll take more interest in some of the legislation we're doing when we have session as young members, young members of the legal profession, and some prospective members of parliament and all of that in there. All right. Thank you very much. Really a pleasure having you here. And for those who might be in the political side, we can, some good minds and thoughts to come in there, send Mocha to come recruiting some of them. Thank you very much, Mr. Anderson. And all the members who came with you. I wish them all well. Hope they get through their exam as they proceed smoothly. And welcome to the profession. We really don't have another topic for the evening. It's about 3:30. I'm looking at the schedule for the next two sessions we have scheduled. My officer is recommending here that we have no further submissions, and we have actually gone through, looking at giving her some time to put all the minutes together, a matrix of the submission that we have had, so when we meet next we can begin to make proposals for amendments.
I'm quite concerned, Chair, that we haven't really received what I would regard as a coherent proposal around this idea of designating criminal organizations and what the effect of that would be and what the standard would be to have that designation made. I see a draft of some provisions here that are some legislative draft of something, but to my mind we haven't reached there yet at all. I think we need to understand the nuts and bolts of the proposal to see if it's something we can endorse, if it makes sense, if it would be helpful or not. You know, and there was a discussion we had around the idea of having the ability to have special measures being employed where you, for a period of time where somebody is considered to be a significant risk, and you want to have some, not so much detention, but investigative tools that can be used, for example, intercept and other things. We have discussed that. I don't know if that's going to be formulated into a proposal or what, I don't know. But I think we need to, there's some work that needs to be done to pull together some of the ideas that have been discussed into proposals that can then be considered properly by everyone, because some of us have been absent when some of them were being discussed and so on, and a lot of them are far-reaching, but they may be good ideas or they may be necessary ideas. But I think I'd like to see that happen. I don't know how we can get that done, but to my mind, that's been one of the disappointments with this process, is that we haven't really, I think, had very cogent and well thought through proposals being put, with the exception of the DPP's office, and I shouldn't say that. There have been some good ones, but I think that there have been some that are still under development, and we haven't really seen the fullness of the idea and what is really being put forward.
I asked the legal team for the ministry to collaborate with DPP and Mr. Bailey, your section, and look at what we have and see if we can put some more thoughts around the suggestion. You're referring in particular to?
I think if they had the minutes, and they could distill out of the minutes some of the ideas that were put forward, and maybe collectively just reduce them into some proposals that we could then consider. Yeah.
Well, she was suggesting, because we're under pressure of giving her some space next week. I think that could be done, and giving the team from the ministry, both the law and policy unit, to pull together the ideas, because we really need now in the next meeting to begin to accept proposals to go forward for amendments. So it would be appropriate to have the ideas put together in a more cogent form that we can discuss them, distill them, and get them to that format. Yeah, that's something that the ministry should pull together with the AG's office, DPP's office, and any other relevant, appropriate agency in government to make sure we have the ideas put together for the minutes. So, get the minutes out to the staff members, and then we can come back. So, in fact, there may be value in doing the next meeting on the 23rd rather than next week.
What I would say is, I know the fierce urgency of now and all that, but having this process actually make a contribution to this, to making this act better, it really, I think, it's a work in progress. Our work is a work in progress, and I would say to you, let us treat it as urgent, yes, but let us at least give the time to have the ideas developed so we have something useful coming out of this. Yeah.
I agree with you that while we have some urgency, we must not move too fast to not do what we like to, which is to give you a better act in the long run. In fact, I made a comment, this was one of the submissions made in terms of human rights, that it's all the challenge in law like this when you deal with criminal law is to balance, to ensure you get a good piece of legislation that satisfies the rigors of your constitution as well, but is also practical and applicable without breaching of the fundamental principles of the constitution. So I think that will do the best. It will, the team has to be coordinated from the ministry with AG, and then bring the other talents you may require, right? So you'll get the minutes out to the legal department, the legal and policy department, along with all the legal departments here. But I say that be coordinated from the ministry to get this together. And we'll then meet again on the 23rd, and we'll try and get the ideas circulated before, so we can all have a chance to look at it, and if necessary, even have some cross-consultation to make sure we have a good job done. Yeah. Yes? What time have it? What time is it? 2 o'clock on the 23rd. Cabinet retreat is finished the day before, 22nd. 23rd is a Thursday, isn't it? Oh, hold on. Hold on. Let me look at the schedule. I thought the day before, yes. No, man, cabinet retreat is Monday, Tuesday. And Wednesday too. Thursday morning? You have a space there?
It's free.
Afternoon? All right.
It's free, and hopefully we get members, sir.
What are the colleagues?
So we're canceling the other 2 meetings.
How are you on a Thursday, Katie?
24.
And in the afternoon, you have human resource. We can't have more than one committee any day.
Yes, we don't have space.
Neither space nor staff. You need a new parliament building. The 30th, you have 2 committees meeting, PAAC and human resource. The PAC is on the Tuesday morning.
PAAC.
No.
PAAC.
Mr. Jackson, I think Mr. Golding will have to make, it's his suggestion. I don't think Mr. Golding want to go up his time. Yes, but on Wednesday afternoon we have human resource. Human resource. And we don't have any.
Chairman,
Senator.
while you're working out the date, in my mind, I'm thinking that you need to give the group that you have spoken to at least 2 weeks.
I think so.
And then, after they have met and distilled their thoughts, you have to give a week for the putting together of this report. And so I don't think we should be thinking of the 23rd and 24th, because that's too early. Yeah.
Let's take the day of Wednesday the 6th, do a morning session, and reserve the day. What are you now? Only afternoon you can come? Yes. 2 o'clock sharp, and we stay as long as we can. And if we need further time, we plan it from then. Yeah, it's an important piece of legislation. We need to get this right. We need time. Seems settled on it, and that allows now to remind the team for the Ministry of National Security to coordinate with all the other legal institutions. Government to put all our suggestions together, get them the cogent, appropriate form. Ms. Aldridge, we hear you. We'll be giving you work here and there, despite of what you have already. And get time for the start to put it together, and we meet on the 6th to begin to fine-tune the ideas and get the actual amendments you want for this piece of legislation. I said it, while it's urgent, I do agree, we must take time now to do it properly. And when we leave here, we'll have a good piece of law with all that we need. That's why. Yeah, we'll ask, we have enough time, so we'll circulate the date and ask everybody to begin. But I suggest that you have discussion with the chairman of PAC behind and PAC. Right. Right. Thank you very much. Ladies and gentlemen, let me thank you all for your support and time given.
They have legislation committee.
All right.